Okay, welcome everybody. See attendees making their way in, so we'll wait a few more seconds and then we'll kick things off. All right, welcome. Thanks for joining us today for our Fiduciary Protection webinar. I am very pleased to get things underway and to introduce our speakers. I'll go ahead and start. My name is Brett Hoffman. I'm a partner and shareholder with Hub International and the financial services practice leader in our Washington, D.C. office. We call it our Mid-Atlantic office. I'm a University of Maryland grad and I'm a Washington, D.C. native, and I will admit, before we start things now, I'm also a fan of the Washington football team. We love that new name. So my firm actually began in 1967. I've been in my role for about 20 years now, just over 20 years. My focus is on retirement plan consulting, investment management as co-fiduciary. We work as fiduciary investment managers, and we help plan sponsors run healthy and compliant retirement programs. And then even more importantly is our team's role in helping employees reach their retirement goals and maintaining financial wellness. I also want to welcome Jesse Cantor with Citrin Cooperman and Chris Frank from John Hancock. And Jesse, if you want to do an intro.
Absolutely. Thanks, Brett. So I am Jesse Cantor. I am a partner with Citrin Cooperman. My specialty is in quality control of financial statement audits. I have been performing audits of employee benefit plans for over 20 years. It really is a specialty of mine. It's a very unique industry, and I love anything related to employee benefit plans. Also work in a variety of other industries, not-for-profits, manufacturing, distribution, you name it, we do it all. I'm also the firm's AICPA Employee Benefit Plan Audit Quality Center designated partner, and I'm happy to be here and share my knowledge with you about EBP audits. Chris?
Thanks, Jesse.
Okay, thank you, Jesse. Thank you, Brett. Good afternoon, everybody. My name is Chris Frank, and I head up the DC consulting team for John Hancock, part of the Benefits Consulting Group. I've been in the industry for over 30 years. I've got 15 years with John Hancock. I'm also an attorney and have served as ERISA counsel in previous positions. My team's main responsibilities are threefold. We work with clients on plan design. We provide compliance oversight, and we also provide fiduciary support, which is why today I'm part of this team talking about fiduciary protection and what you should know, what you should do. And with that, I'll turn it back to Brett.
Thanks, Chris. And I don't want to leave Chad Stewart out. Chad with Hancock is on as well, and he's managing our slide deck today. So thank you, Chad, for helping out. So thanks everybody for joining us. I'll start off with some slides on the markets, the economy, COVID-19, then we'll get into some other fiduciary protection and audit strategies with Chris's portion on DOL audits and other COVID-19 considerations, and Jesse's slides on top 10 challenges for employer-sponsored plans, including virtual audit challenges, and lots of, I think, good information for everyone today. So first off, the economy. So businesses have been impacted severely. Retail, restaurants, travel, as we all know, have been the hardest hit. Unemployment rate has crept up over 10%. We haven't been at these levels in decades, and it was actually up to 14%. U.S. has lost over 20 million jobs. Federal aid has certainly helped, but we just don't know right now if there will be more or how much. Second quarter GDP decline of over 9.5%. And so we were hearing a lot about those numbers being annualized to 32.9%, which is very scary to have a GDP decline, much less closing in on 10%. But we've already come off these numbers. We've already seen improvement. That was at the height of the shutdown and quarantine earlier this year. So we do expect those numbers to improve, but that, we are still, experiencing what we would call a recession by textbook definition. So social distancing, states are looking to independently decide when to reopen. Certain sectors we've seen flare-ups this summer. Testing has definitely improved. It's over 800,000 tests per day through July, but that varies greatly by state. And we really need to see things drop below 5% positivity in testing for 14 days in a row. According to the World Health Organization, to see consistent containment, we need to see that everywhere. And there have been spikes in certain states. You've seen it on the news. Maybe some of you have vacationed down south. South Carolina was over 15% positivity in tests. So this slide talks about global economy and the share of world GDP. And we think it's interesting. You would find it interesting to know that the US consumer, if it was a standalone country, it would be the largest in the world by GDP. So with 95% of the population experiencing the lockdowns, at least at some point this year, it just goes without saying that US consumption is likely to falter until restrictions are eased or eased even more. So China's GDP is smaller than the US consumer spending, which really says a lot. And then you can see UK, which is a huge economy, is not even 4%. The next slide, continuing on that kind of global, consideration, we're looking at monetary policy. Very accommodative now. As you all know, interest rates have been slashed, and we've really seen, central banks doing whatever they can to keep money in motion. It's helped the markets. It's helped the economies. We haven't seen these levels since the global financial crisis in 2008. So fortunately, we have seen, throughout the world, central banks taking action, which has been a positive influence. Next slide, we'll talk about how long the typical recession. We get this question a lot, how long are recessions and are we in one? Yes, we've seen the economy decline, economic growth decline, GDP has declined. So I would say we're in a recessionary environment. On average, recessions last about 13 months, so about a year. The interesting thing on this slide is that the 1918 recession, which was really triggered by the Spanish flu, which was the last global pandemic, it lasted about half as long as a typical recession. So the recoveries can be very swift. And so we want to keep that in mind as we're planning and we're communicating out as fiduciaries to our plans participants. 2007, the recession lasted about 18 months. And we all remember it felt like years, but it was 18 months as we came out of recession. On our next slide, I want to talk just for a minute about that diversification that we all know is so important for our employees and participants in plans, and as fiduciaries, we need to continue with that messaging. But this is looking at the S&P 500, which we know now is very heavily weighted towards large tech growth companies like Apple, Amazon, companies like that. Diversified portfolios tend to hold up better in down markets and tend to not do as well in rising markets. So 2000 to 2002, the tech bubble, what did people say? They said, I lost money. Maybe they lost less in the markets, but they said they lost money. 2003 to 2007, the markets did well. What did people say? They said, well, I didn't make as much. 2008, markets were down 40%, even more at one point. Diversified investors down 24%. Again, I lost money. And then we had our wonderful 10-year run. And what did diversified investors say? I didn't make as much. So when we bottom line it and you look at this 20-year period, you can see if someone had $100,000 invested over that time frame, the total return for a diversified portfolio actually is better. And because in the down cycles, which come and go, they tend to hold up much better. And we saw 158% positive return on that diversified portfolio compared to someone who was just all really focused on the S&P 500. So 100,000 grew to 250,000, better outcome. So diversification wins even when it feels like it's losing. A couple more slides on the markets. This talks about looking at an investor that consistently sold since 1936. That's a long time frame to look at, but sold 10 months prior to the peak of the market, bought back in 10 months after the bottom, was actually worse overall than a buy and hold investor. So someone that was able to time things right, really every time over 70, 80, even longer periods of time, it really showcases how the impact is better really to the person that just bought and held. So $100 grew to $22,000, $100 grew to $8,800 for the market timer. So again, it's getting that messaging out to participants about staying the course and having good long-term diversification strategies. Next slide. This is one of our team's favorites, and our firm really likes this, and we found that our clients like this too, because it really hits home. So how many years since 1926, prior to the Great Depression, through the 1920s, 30s, World War II, all the way to present day, how many times have we seen the markets lose more than 20% a year? 6 times. How many times have we seen the markets gain more than 20% a year? 35 times. In 20 years, we saw the markets return greater than 10%, 10 to 20%. And you get the picture. So in 55 years, we had really positive returns of 10%, even north of 20%. What do people remember? We feel the pain. We remember the down years. So I think this is a good slide. It's something that I would encourage people to, message out to your participants, especially those that are getting nervous in this economic market, the conditions that we're in currently. So I'll go ahead and start to wrap up my piece here on the next slide. The key takeaways. So from a perspective of fiduciaries communicating out to participants, what you need to be saying, what kind of messaging we want to have to protect yourselves. Well, picking your appropriate risk tolerance for your plan and for participants and giving them resources, consulting with your plan's investment advisor, using online planning tools. Diversifying your investments is obviously key. That's kind of the 101 level, but we forget about that and we get sucked into different trends. So diversification long-term, sticking to your long-term plan regardless of market volatility, increasing contributions annually, trying to target a 10 to 15% savings rate. And volatility is just normal. It's part of the ebbs and flows of the stock market. COVID-19 caused the markets to go down the way they did earlier this year. We've since recovered. We're not finished yet, obviously, but the market's recovered very swiftly. And it's really just messaging out as fiduciaries, reminding your employees and your plan participants to think, staying the course is often the best thing to do. So I'll leave you with a quote. It's not my quote. It's Warren Buffett. He's made several billion in the market as an investor. Success in investing doesn't correlate with IQ. What you need is the temperament to control the urges that get other people into trouble in investing. So we have to really take the emotion out of it. And I think as plan sponsors and fiduciaries, hopefully I gave you a few good ideas. Chad, if we can go one more slide, and what we're going to ask folks to do is to use the Q&A feature for any questions you have for myself, Jesse, or Chris today. And we have a coronavirus resource center that's right on the Hub International website. I don't think that link there is live. So hubinternational.com, coronavirus resource center is really good. You can go to that and get lots of excellent information about risk management and retirement plan resources. We have a text feature there if you want to get updates. Those are excellent as well. Questions, you can feel free to call in to our firm. The 800 number is there, and that email address comes into our team. So if you have questions you think of after, feel free to email 401khelp@hubinvestmentservices.com. So thank you for tuning into my portion. I'm going to go ahead and hand it off to Chris Frank to go over some additional fiduciary protection strategies.
Okay, thank you, Brett. So the name of my section is called Fiduciary Protection. Is your retirement plan ready for a DOL or IRS audit? And obviously, this type of presentation was very relevant prior to the first quarter of this year. Do I think it's relevant today? Absolutely, with a few caveats, and that's kind of what I'm going to do. Going to the next page, just to quickly kind of go through the agenda. I'm just going to set the retirement plan landscape for everybody, then provide a little bit of an overview on audits. And I'm talking about, just to be clear, I'm talking about regulatory audits. You're going to hear from Jesse afterwards on plan audits. And then what's the difference between DOL and IRS? What are some helpful audit tips? Then focus on the COVID-19 considerations, and then sort of leave you with some fiduciary best practices. So let's take a look at the retirement plan landscape. So I think the first thing that I need to confirm with everybody is that retirement plans continue to evolve as one of the top litigation targets. There's been a lot of ERISA litigation. We've seen a number of cases reached the Supreme Court. Intel is one, the Thole case is another. We've had plan sponsors pay out over $6 billion in ERISA class action lawsuits since 2000. One that comes to mind is the Tussie case, which after 12 years, can you believe it, 12 years, finally reached a settlement, and it was a $55 million settlement. And I don't think I have to tell you where most of that money went. But yes, it did go to the attorneys. So that's litigation. You've also got the DOL and the IRS conducting thousands of plan audits each year, even though there is a capacity issue with them, lack of resources. They still conduct a fair amount of audits. They've actually gotten a little smarter, a little bit more efficient with the way they conduct audits. The DOLs also recovers a substantial amount of money through enforcement actions. So not necessarily going the audit route, but sort of seeking out plan sponsors who seem to be in fiduciary breach. And that number is over 1.1 billion. That was for 2018. So sort of setting this landscape and giving you these facts, the questions really are, how can you, the plan sponsor, mitigate fiduciary risk, and how can you avoid personal liability? Because plan fiduciaries can be held personally liable, and you don't want to sort of fall into that category. So that's the retirement plan landscape. What about audits in general? So your plan can be audited by one of two regulatory agencies. You can be audited by the DOL, and that's through their Employee Benefits Security Administration Department, referred to as EBSA. And then you've got the IRS. So you've got these two regulatory bodies. People always say, well, what's the DOL do that's different from the IRS and vice versa? Well, the DOL is focused on ERISA compliance and protecting plan participants, which means they're going to have a heavy focus on whether or not you're complying with your fiduciary responsibilities. The IRS, on the other hand, is focused on ensuring that the plan is in compliance with plan rules, that operations meet plan document language, because they're trying to determine whether a plan has that tax favored or qualified status. Now, the way these two regulatory bodies find audit candidates, it varies. They can vary on a number of factors such as geographical region or industry. And as you're going to see when we jump to the DOL audit section, that they can be notified of fraudulent or fiduciary breaches from a number of different individuals or service providers. So as I mentioned, that despite agency budget constraints, there hasn't been a noticeable drop-off in regulatory audits. Even during this COVID-19 stage, this last 5 months, the two regulatory bodies have relaxed some of their rules in terms of turnaround with various pieces of information. And they've also sort of avoided the in-office visits, but they're still conducting audits. So I guess the tagline or comment I want to leave you with is, your fiduciary duty is constant amid the chaos and change of COVID-19. So you really can't afford to take a vacation from your responsibilities, or just say, you know what, we've got too many other things we're worrying about. We can't worry about the plan. We can't worry about the participants. We'd like to, but you know, I'm sure the DOL or the IRS doesn't mind. It's just a chaotic environment. So I'm sure they'll understand. And that's not the approach to take. And that's the message I'm going to try to put forth today. So moving on, the DOL. So what triggers a DOL audit? What usually triggers an audit? The DOL could have targeting initiatives. Fees are always going to be a hot button with the DOL. So if they have an initiative where they're trying to determine if, most plan sponsors are charging reasonable fees or paying reasonable fees, that could be one of their targeting initiatives. They audit a plan, they want to make sure that the fees being paid or charged to participants are not excessive. They're also going to look at Form 5500 responses. So just make sure that your Form 5500 is completed accurately, and that if you answer a question like, have you ever had a late deposit, and you check off yes, you better be ready for the ramifications, whether it is an audit or whether you get a letter asking for more information about that late deposit. So you need to have backup information on some of your answers to the Form 5500 if they are going to be interpreted in a negative way. You also have participant complaints. They set off a lot of audits, and the DOL has made it pretty simple for participants to I'll call it ratting out their plan sponsor, whether it be the website that they have set up, the 800 number. Participant complaints are taken serious. And then service provider investigations. It's not just plans that are audited. Companies like John Hancock can be audited. And as our procedures, operations are being viewed, we may be asked questions about certain plan sponsors. So again, these are the 4 common triggers. Now, if you are selected, how does the audit start? Usually you get contacted, most likely with a letter. Sometimes an agent might call just to say, hey, this is what's going on. We're going to be starting an audit. This is what you should expect. But at a minimum, you need to get your plan documents together. You need to get your plan fiduciaries together. You might get questions about fiduciary duties, like how quickly do you turn around your employee contributions? You might get questions, this is another hot button with the DOL, about how do you handle lost participants? So somebody terminates from the company, has a balance in the plan, they never take out a distribution, you try to pay them out, you can't find them, there's no address, you go through some of those lost participant searches. What are you doing? Have you tried or exhausted all possibilities of finding that person? They're going to ask these types of questions. Moving on to the next slide. Once they get all your information, they'll schedule a visit. Like I said, given that we're in this sort of chaotic and social distancing environment, they could be doing calls. They could be delaying some of the steps of the process. But they are going to meet with you. And how it used to work, or how it could be working after we get through COVID-19, is the DOL agent would come in. They might set up in one of your empty conference rooms or offices. They might stay a couple of weeks. They might go through all their inventory items, make sure they've collected everything. And then they sort of disappear and you don't hear from them at all. And it could be months, and there's really no way of finding out where you are in the process. And then all of a sudden you'll get a letter. Now, the best letter to get is one that says no findings, which means you got a clean bill of health from the DOL. The next best closing letter is findings but no action letter. And those could be, hey, we spotted a couple of things. We think you need to tighten up this process, or you need to provide this type of information. Again, not too bad. The less favorable result is one that recommends a voluntary compliance process and a formal settlement. This is not where you want to go. You never want to get to this place, because that could mean all kinds of things, especially penalties to the plan sponsor. But there is one other level that's worse, and that's the referral for litigation. This doesn't happen often, but this could take place if you're in disagreement with the DOL's findings. So again, there's a lot that goes on here. I've sort of condensed this. This could be a 3-month process. That could be a 6-month process. It could drag on longer. But again, the thing to know about the DOL is they're not really forthcoming with what they're looking for or what they're doing. They're never going to give you a really good time frame like, hey, we'll get back to you in 2 weeks. We'll get back to you in a month. Hey, this is what we mean by our letter. Fortunately for us, I have 2 people on my team that have spent some time working at the DOL. So a few times I've had to go in and say, hey, can you read between the lines here for me? What are they looking to do? What's sort of their next steps? What should we be doing? So if you run into a DOL audit or an IRS audit, make sure that you bring in a reliable expert, a third-party expert, to sort of guide you through the process. So let's compare this now to the IRS audit. So what do they do differently? Well, the IRS usually uses a centralized case selection and review process. So they're the regulatory body that will say, okay, let's focus on safe harbor plans, or let's focus on companies in this particular industry, or let's focus on companies of a certain size. So they create sort of a target list of audit versus a participant like claiming they've been they've had an issue or they've been subject to a fiduciary breach. The IRS will sort of create a list, a target list, and then sort of reach out to these plan sponsors. So what are the IRS, what are they looking to do? So some of the items are overlapping with the DOL audit items, but they're looking to see if you've timely amended your plan documents, or are you administering your compensation and eligibility rules consistent with plan terms? Have you approved loans and distributions according to applicable law and plan terms? And then are you providing contributions, benefits, rights, or features that don't favor highly compensated employees? And that's a theme. You're going to see that you could have made a mistake and maybe it benefited only non-highly compensated people. And you're not going to get sort of the same impression as you would if there was a mistake that violated highly compensated employees. So there definitely is a bias towards highly compensated employees. There's always going to be more, I think, disciplinary action where highlies have benefited versus non-highly. So that's just a tip to keep in mind. And then like the DOL, you'll be notified by phone or letter with certain follow-up. Next slide. Okay, and again, you're going to be asked for things like your plan document, your determination letter, various annual reports, evidence that you have a fidelity bond. Hopefully you all have a fidelity bond. That's an ERISA requirement. If you're a safe harbor plan, they might ask for a copy of your safe harbor notice. That's actually an IRS notice versus some of the DOL notices like a QDIA notice. And then you might get a second letter asking for things like your ADP and ACP test results. They might ask about your 401k deposits, your participant loans. They might do a few test cases to make sure that the loan was for an acceptable amount for the term within 5 years. So there's a lot of different testings that go on after this initial inventory of items. Next slide, please. And again, to begin the examination, you or whoever is representing the plan might be asked to explain administrative practices and procedures, so they get sort of a comfort level with your plan and the individuals they're dealing with. Depending on how that conversation goes, depending on how their initial review of documents goes, the scope could be expanded. Hopefully it's not. They might require additional information. They might require corrective action prior to concluding the audit. Unlike the DOL, they'll explain the areas that may require attention or corrective action, or at least they'll be more forthcoming. You know, once the examiner's work's done, it then goes to a manager and they review as well. And then again, the final step is you want to get a letter from them saying, hey, we looked at your plan and everything's okay. Next slide. So with the IRS, a plan that has significant problems discovered upon audit enters their audit correction program or audit cap. This is where you're dealing with penalties. And usually you start with a high number and you try to negotiate them down. Worst case scenario, remember in all cases, worst case scenario is your plan can be disqualified. So hopefully they don't start at that level. They start more with this is what we're looking to place on the plan. It's going to be a penalty of X amount of dollars, and then you try to whittle down that penalty. And then under audit cap, you enter into a closing agreement, you make your corrections, and as I mentioned, you pay a sanction negotiated with the IRS. And again, the sanction is determined based on facts and circumstances. It's not, okay, you fall in the severe category, so it's $50,000, or you're in the middle category and it's $20,000. They look at things like what would be the tax exposure if the plan was disqualified, and maybe take a percentage of that and then say, okay, that's our starting point, and then you work your way down. Next slide, please. So again, what's the things to come away with? Well, the IRS and the DOL both have published self-audit tools, so you should familiarize yourself with those resources, and you can get those right off their websites. If you were interviewed, two things to remember: always be truthful and don't guess at answers, and only answer the questions that you've been asked. You don't get like bonus points for saying more than what you're being asked. And sometimes if you say more than what you're being asked, you're gonna go down a rabbit hole. So you gotta be careful. If you're responding to request letters, make sure your responses are well organized and complete. And remember that the DOL and the IRS, they can go back a minimum of 3 plan years. So you may get a letter that says you're being audited for 2017. They can go 3 years either way with that. But if they discover substantial errors, they can expand this to cover 6 plan years. And again, you don't want to get to this point. So the bottom line is your cooperation may affect the outcome of the investigation. So be polite, be precise, don't guess at answers, and always show them that, you know, you have a true commitment to being a plan fiduciary. Okay, next slide. Next slide, please. Okay, so again, I mentioned before that a lot of what I said was all really good information prior to COVID-19. So what should you know about COVID-19 considerations? So what should you expect maybe a year from now, 2 years from now in terms of audits? So I would say that, well, first and foremost, you shouldn't expect relief from litigation, and you shouldn't expect audit relief. There is some relief being provided this year, and I point to the DOL's EBSA disaster relief notice, which gave plan sponsors relief from certain deadlines regarding participant contributions, different notices, authorizing loans and distributions. Obviously, the DOL understands that businesses have been affected and they might not be able to handle all their responsibilities timely. But the thing about that is that it has to be solely attributable to COVID-19. That's not a get out of jail card, just saying, oh, well, COVID-19, I couldn't get this notice out. You know, there's got to be some proof to the fact that that had an effect on your business operations. So what are some of the things they're going to be looking at if they audit your plan a year from now, 2 years from now? So they're going to look at things like, did you timely amend your plan documents for employer contribution suspension or elimination? Now, we've worked with a lot of clients who got to a point where they had to make some cost concessions and they had to suspend the plan's matching contribution or eliminate it. And okay, understandable. But did you amend your plan document timely for that suspension or elimination? Or do you have some other evidence like a board resolution? Also, did you have to lay people off because your business shut down for a period of time? And usually when you lay people off, depending on the percentage of people compared to the overall population, you could have had a partial plan termination. And that triggers things like accelerated vesting. So they're going to look at things like that. Also, things, did your plan compensation definition change as a result of certain regulatory releases? So what you might find is that your audit might have a real COVID-19 focus to it a year from now, 2 years from now. And then just the CARES Act adoption. And you might even want to throw the Secure Act in here as well. Did you adopt the CRD provision? Like, are you allowing these special distributions for people who have been affected by COVID-19? Did you relax the loan limits? Did you allow loan suspensions? How did you handle 2020 RMDs? Because RMDs were waived for 2020. Did you amend your plan for all CARES Act provisions that you adopted? Now, amendments aren't due to, or the deadline for amendments for the CARES Act aren't until December 31st of 2022. But again, it's something to put on your checklist of things to be aware of as we hopefully move out of the COVID-19 environment. And then just lastly, your fiduciaries, what should you be thinking of, or what are the areas you should be focusing on? Well, plan governance is always a big item. And plan governance covers, do you have a committee? Are you meeting regularly? Are you taking minutes? The one thing to know about plan governance, and I mentioned this before about you're not able to take a vacation from your responsibilities. If you need to adjust for COVID-19, adjust. We're having a discussion today. It's a Zoom meeting. You can have committee meetings by Zoom. There's no ERISA regulation that says you all have to meet in person. So you have to adjust for COVID-19. And I mentioned this before on the audits. You got to make sure your plan documents are timely executed because if you're audited by either the IRS or the DOL, they're going to look through your documents. Plan compliance is also important. Make sure your testing is completed. Make sure you file your Form 5500 timely. Make sure you get out notices. Plan operations, again, other than that relief I mentioned, make sure your deposits are timely. Also, make sure that you are aware of personal identifiable information, or PII. Make sure your service providers have talked to you about their cybersecurity policies and procedures, because that is important, especially in this day and age. Delegation, it's very important. If you don't understand certain things, if you need assistance to carry out your fiduciary responsibilities, make sure you hire third-party experts, like Hub International. It's very important that you fulfill your responsibilities in a prudent way. And again, delegation is important. And then I think Brett hit on this before, education and communication. Adjust your communication. You know that it's been a very volatile market. And if you need to sort of get communication out to people that talks about market volatility and things to that effect, or if you've adopted the CARES Act provisions, You want to make sure they understand what they're entitled to under these new provisions. So again, you're continuing to act as a responsible fiduciary. You're just adjusting according to COVID-19. So I'm going to end it there. That's my formal comments. I don't know if there's any questions. I know I can't see them, but Jesse, was there any questions that have come in?
There's a couple of small questions. I think we'll handle the questions at the end because we
Okay.
might have some additional questions that kind of piggyback off some of these questions that have come in once I go through my presentation as well. So we'll hold off on questions for now.
Okay.
But if we can advance a couple slides to my main presentation here on the retirement plan audit landscape. So I've kind of put forth, the top 10 challenges that I see regarding retirement plans right now as it relates to our current environment. These things kind of change, year to year, but a lot of them, stay the same. But there's definitely going to be some emphasis on a couple of these items as we are in the COVID environment and some of the regulatory changes and so forth. So Chris discussed, a little bit about the CARES Act and the Secure Act. And Chris, thank you for that presentation. It was absolutely fantastic. I hope everybody was taking notes. It was really, a lot of good information, and it's going to piggyback a lot into what I'm talking about here that everyone needs to think about from an external and from IRS or DOL audits as well. So the first item here relates to the CARES Act. So you can apply these provisions before the plan formally adopts. So it's a very different way of thinking about these regulatory adoptions because, the legislature wanted to get out these provisions, immediately so people could get their money out of the plan if they did need it. So they are allowing the provisions to be in place before the plan is actually adopted. So, there may be some confusion because these provisions are an election as well. So the provisions of the CARES Act, they're not across the board. The plan does need to formally, put those provisions in place. Okay, so the plan doesn't have to apply them. And we are seeing a lot of opt-in communications from third-party administrators to ask plan administration if they want to apply the provisions or not. And through all this, those third-party administrators had to act really fast, and the payroll providers had to act really fast. So there's bound to be some mistakes along the way that will need to be corrected. So the CARES Act provisions are certainly something to watch out for. And those are, of course, are the coronavirus distributions, the CRDs, and the loan provisions, relaxing the rules surrounding the participant loans. So next is the Secure Act. Those changes don't concern me quite as much as the provisions in the CARES Act does, because plan administrators have had more time to take those provisions in and apply them to the plan. The major change here, of course, being the update to the Rmd age, so the required minimum distribution age from 70.5 to age 72. There's also some good changes in here to promote more savings, like raising the default savings cap in auto enrollment plans from 10 to 15%. A big change that will affect plans is the change in what we think of as part-time employees for exclusion from retirement plans. So previously there was that 1,000-hour mark where you could exclude certain employees who worked under 1,000 hours and kind of called them, those are part-time employees. Well, that hour cap has changed from 1,000 hours down to 500 hours, which is going to cause a lot more part-time employees to become participants in the plan. And there are many other changes, but one last noteworthy one is increases in penalties that can be imposed by the IRS when certain forms and notices are not filed timely. So Chris talked a lot about, IRS, audits and, some of the penalties that they impose and the sanctions. They're also, as part of the Secure Act, looking at timely filings and notices. And some of those fines can be quite substantial. All right, number 3, so COVID again, the remote workforce. And whether it's your participants or your plan administration, there are many people working remotely. And we've had to come up with a lot of different processes on the fly. Getting signatures has proved to be tricky for some, and communication. So all three of us are mentioning communication here. Communication is more important than ever. All right, number 4, year-end audit requirements. They must go on, right? For large plans, they are required to have an annual audit that must be attached to the Form 5500. And there has been no talk, at least from the DOL. There's been a lot of talk on the audit front from us, from the audit firms, talking about extending the 5500 filing due dates. Right now, they are due October 15th. That's the extended due date for our calendar year-end plans. We are waiting patiently to see if the DOL and the IRS extend that due date, but as of right now, there is no extension for our calendar year-end plan. So October 15th is it. It could happen, but right now we're marching on towards October 15th. And these audits, they are being done. For the most part, they're being done remotely. And again, thank you, COVID. All right, number 5, compliance requirements. Like our audit requirements, we also have compliance requirements to pay attention to. Plans still need to be tested for non-discrimination. There are IRS rules and regulations to abide by for participant transactions, including the timeliness of remittances. And Chris did mention that there's been some relaxation on the requirements for timeliness of contributions, but there's nothing set in stone. And of course, the DOL could come in under audit and take a look at the timeliness of those remittances. And if they don't feel that your reasoning is appropriate, given your operations, they can call those late. Okay. Always be sure to document your compliance testing. Keep all the backup for participant transactions in the employee files. You'll be glad you did when it comes to audit time. And another big one that demands attention during COVID is workplace reductions. Chris mentioned partial plan terminations. So significant workforce reductions will lead to a partial plan termination. We've already seen a number of them in 2020. Generally, that number is 20% of the workforce, but it's very facts and circumstances based. Okay? And this means that all the affected employees become fully vested in their accounts. And the plan will be dealing with large volume of distributions as these employees exit the company. All right, service providers, always important. And something that will always be looked at by DOL auditors and us as your external auditors is monitoring your service providers. It is a plan sponsor's responsibility to monitor those service providers. And this can be done in a few different ways. One, I always recommend that the plan administrator obtain the SOC 1 report. Read that report and discuss any findings and exceptions with the service provider and or your other plan advisors to understand the impact on your plan operations. 2, have regular discussions with the service providers to understand how they are safekeeping your participant accounts and complying with rules and regulations. And 3, talk to your participants. Have they had any issues with the service providers to your plan? And then obviously follow up on any complaints that you hear from your participants. Okay. Related to number 8 and number 9 that I have here, service providers can help greatly with both education and participation in the plan. So make sure to have your plan advisors do regular education for your employees so your employees understand the plan, so that they understand the benefit that they can get out of the plan and also to increase your participation in the plan. Having that service provider discuss the plan with the employees drives participation up in all cases that I've seen. And lastly, certainly not least, but lastly, document everything. Everything I've talked about here deserves documentation in your plan files. Keeping clear, organized documentation will also help with audits of the plan, both on the external audit side, when we come in to audit your plan, but also from a DOL and an IRS standpoint. Chris mentioned being as organized as possible when you are going through those IRS and DOL examinations is going to be, a huge benefit to you. So you'll be glad that you did it. All right. Then on the next slide, we're going to talk a little bit more about best practices in this environment. Okay. First, the regulations are changing constantly. Acts in the future will likely impact plan regulations, as these plans are tied closely to tax law, employment, and benefits. So, keep an eye out for changing regulations. And don't go it alone. So much info is out there to sort through. Use your experts. Know employee rights and regulations before making decisions. Part of monitoring your service providers is keeping close to them. So talk often and use their services, but also make sure that you're monitoring those services. Communication, maintaining strong communications. All three of us have mentioned communications. Communicate often. Communicate with your service providers, your participants, company management, everybody related to the plan. And of course, documentation is so important. So for an IRS or DOL audit, it's important, as well as for your external financial statement audit and compliance tests. For participant transactions, if this is done through HR, keep a copy of everything. And consider outsourcing to your record keeper any transactions so that you can ease the administrative burden of your own employees. They are the specialists. Just make sure to monitor those activities, and your SOC 1 is a huge help on that. And now let's talk a little bit about the virtual audit on our next slide. So Chris gave a great summary on the audit process. And as an external auditor myself, my thought is that the audit world is turned totally upside down. We are used to being at our clients' locations every day. The IRS and DOL examiners are used to their field visits too. And now everything is done through emails, through portals, through Microsoft Teams meetings, through Zoom meetings. We're using screen sharing to obtain audit evidence. Clients are scanning and emailing everything versus, handing the auditor a stack of participant files and a flash drive with payroll information. Everything is driving to electronic, which also means that we need to be very careful with confidential information. So there's a lot of changes taking place. Our teams, they're essentially performing our employee benefit plan audits virtually. And this is our employee benefit plan busy season. So we have a lot of these audits going on right now, and virtually all of them are being done remotely. And they are utilizing some pretty creative methods to obtain the audit evidence needed to issue that audit report. Okay. I've also gone through, or I'm still going through, an IRS examination with one of our clients, and it's done totally virtually. So they got the letter that Chris talked about. It gave a deadline to get back to them. They then gave us a letter with some requests, and we had to get on the phone with the IRS agent and say, okay, well, how are you going to do this? The letter that came to us was a canned letter. It talked about field visits. It talked about calling the agent and arranging a time to come out and having all of the the files available for them to look at. So we had to have a discussion up front and say, you can't do that. You can't come to the client's offices. Everybody's on quarantine, and meanwhile it was probably late March, early April, so right in the thick of things. So we did a virtual audit. We had phone calls with the agent. I was given power of attorney. We had to fill out some very specific, I'll call them waivers, although it wasn't a waiver, but some very specific language so that the IRS agent could communicate with us via email, because that is not their normal practice. And we're getting through it, and we're almost down to the last little bit of information that they need. But yeah, the IRS is doing these virtually as well. And I haven't heard of any of my contacts going through a DOL audit at the moment, but I suspect that the DOL is also handling all of their audits virtually as well. They've generally been a little bit more on the cusp of technology and utilizing data sharing electronically than the IRS. So I'm sure that they were able to convert a little bit easier than the IRS. But the key here, we all need to be flexible. We all need to work as a team, and communication is definitely key when we're talking about these virtual audits. And then before I hand it back to Brett for some closing remarks in our Q&A, I just want to leave you with some resources here on the next slide. So we at Citron Cooperman have developed our COVID response unit. You can see the link there to go and check that out. The page has a ton of information and resources for all industries, also some general tools like our endurance assessment. So check it out. Feel free to use any of those free resources up there. The IRS, the AICPA, and EBSA as well also have set up their own corners on their websites for coronavirus information. A lot of the information out there, it's really good, helpful information and getting us through this very difficult time, as it relates to our employee benefits and company operations in general. So, and I'm going to hand it back to Brett.
All right, thank you, Jesse. Great job, Jesse. Great job, Chris. Appreciate it, and thank you for the questions that came up. We had a couple, so let's try to hit those real quick. We will circulate the slide deck. I think we'll be able to get that out to everyone. We plan on doing that, so no worries. We'll make sure you get a copy. I'll take this one real quick. The S&P 500, is it better to invest in other portfolios other than the S&P 500? So I won't say it's better, but definitely as plan sponsors, we talk about communication. That's a theme we're all coming at this from our different areas of expertise, and really communication and offering a wide range of options to your employees and your plan participants is still just of the utmost importance. Let them decide, self-directed plans, let them decide, but give them a lot of options. And so we highly recommend that you personally diversify, but make sure your employees have a lot of good options, index funds, actively managed funds, and everything in between, and giving people up. Not too many, I should couch that comment, but not too many, but enough to be diversified. You probably need to have 15 to 20 options in your plan, and good target date funds as well. And again, documentation, make sure you have a good process for showing how you landed at the decision on the funds that you offer. Can you define CRDs and RMDs? One of you guys want to take that?
Yeah, so the CRD is the coronavirus relief distribution. So in the CARES Act, part of the provisions there are special, I call them special distributions related to the coronavirus. So if somebody has been impacted by coronavirus, whether it's being laid off, furloughed, having to stay home because of childcare or schooling or what have you, you can avail yourself to a coronavirus relief distribution if the plan offers it. So that is one of the provisions where the plan has to actually elect to apply those provisions. They do not have to. And the RMD is the required minimum distribution. So that's the distribution when the participant hits age 70 and a half, or it will be 72 for, when the Secure Act provisions are in place. They are required to take a minimum distribution, which is calculated by the third-party administrator using IRS tables. If they're still working, they are required to take that out of their plan, or if they're retired either.
Thank you, Jesse. And we did find that not every company put the CRDs in place. Not all companies did. Most, I would say, did, but not all. They found they didn't need to because of their industry, or they wanted to wait and see. And you can add it later if you're one of those folks. You didn't add those distribution provisions for CARES Act. You can add it at any time.
Yeah, thank you for that, Brett. I was actually going to ask you if you've been seeing your client base put that in place. We've also seen along the lines, similar reaction to it. We've had a couple that have put them in place, and we've had a fair number that have not, and have decided that they will not. And we are asking that of all of our clients because we are, like I said, we're going through our busy season now with our benefit plan audits, and that's part of our subsequent event inquiries of our clients is, did they put those in place? Are they amending the plan for those provisions? Because those are disclosure items. But we're finding a little bit of a mixed bag, but
The one thing to keep in mind too with the CRDs is Congress made those self-certification. So unlike a hardship where you have to provide proof of the hardship, it's only a matter of time until we find out how many people took advantage of self-certification. And I know we've had some plan sponsors say, hey, what if we find out 3 weeks after we give somebody a CRD that they didn't meet the requirements? And I guess My response would be, look, you would treat it like any other impermissible distribution and follow sort of the steps to recoup the money. So you find out after the fact, well, you were allowed to rely on self-certification. You find out after the fact, you make some kind of attempt to get that money to be put back into the plan. And again, more will come out of this in the next 3 to 6 months. Right now, we're in that sort of, hey, look, anything for the participant stage.
Right.
Yep.
Exactly. And some plan sponsors have the mindset, this is retirement money and that's all it is. And they've
That's true.
You know, stuck with that, even though, you know, some people are maybe need to get access to it. So interesting comments around that. We did get another question. If we have Fidelity as our administrator and 338 advisor, which is an investment manager, meaning they're basically picking the funds and signing off as a fiduciary, as a 338 advisor. Are we covered as far as compliance? So I'll give you my take on that, and then I'll let you guys chime in. My thought on that is that covered is a very, I'm not an attorney, Chris, but covered is a very broad language. Are you covered? You definitely have a process because you have a 338 advisor. Are you covered? You still need to have a process as fiduciary to show that you're keeping an eye on that service provider. Even a 338 investment manager, when it's completely outsourced, you say, well, they pick it for me. You're still ultimately, it really comes back on the plan sponsor every time. But I do think that's an efficient way to build your menu if you're okay with having it selected for you. 338 is a good approach. But that's my take, is you're not covered, but it is potentially a good process as long as you're monitoring that process.
Well, the statement I would add to that is when you're a fiduciary, regardless of your setup with other third parties, you cannot operate blindly.
Right.
So, yes, it might be the best scenario for you to have a 338 because your committee doesn't have the expertise, but you can't just set it and forget it. You have to do, and I think everyone has said it. Jessie said it in her presentation. I think I alluded to it. Brett, you've said it. You hire a service provider for whatever service, and especially it's more critical when it's a fiduciary service. You need to monitor that provider. So sure, they're a 338 fiduciary, but are you meeting with them? Are you doing your due diligence? And that's what's going to be critical in that relationship is, have you done due diligence with all your service providers on an ongoing basis?
Great points.
Absolutely.
Yeah.
We did have one last question. I think we should answer that one. We only have, I know we're a little over time, but bear with us. This one specifically for Chris. How have you seen the fiduciary responsibility change in this virtual environment, such as, proof that people are actually, conducting their fiduciary responsibilities, like the review of fees, the review investments that you just went over, transactions, sign-offs and what have you?
Yeah, I think people using Zoom, people using whatever virtual meeting functionality they have. The important thing, and again, we've all said it, we've said it multiple times, is you're documenting decisions, you're keeping good meeting minutes. Your topics are probably different than what they were 6 months ago. So you're talking about participants and you're talking about all the things we've brought up, furloughs or handling furloughs, because furloughing a person is not a fiduciary action. But how you handle the ramifications on the plan is the fiduciary action. So we talked about partial plan terminations. Is that being discussed at committee meetings where, okay, now we've reached that magic number, it's 20%. Are we looking at the plan and making sure that vesting has been accelerated for those people that need to receive it? So I think that's going to be the test, is when someone looks at your committee meeting minutes from, just say, March to whatever date we want to put on the closure of this, do they reflect the topics of the times? And if they don't, then something's wrong.
Yeah.
it's like, I think the comment I made was adjusting your plan governance to meet the current environment.
Great, thank you. I do know we spilled over on time, but we want to thank everybody for attending. So I think we should go ahead and wrap up. Really appreciate it, everyone attending. I think Jesse and Chris, great job. This was fun. It was informative. I hope everybody got, like Jesse said, pages of notes. And we'll circulate our slide deck. So documentation and communication, we'll just wrap it up. That's and adjusting for the times and adjusting for the times. So
Great takeaways.
thanks, everybody.
Thank
Have a
you.
great
Thank
afternoon.
you all.
Take care. Stay well.
You as well.